My name is Jeff Morgan. I'm from Dallas, Texas. I am the person who's challenging the constitutionality of Texas Family Code 6.001. That is the insupportability statute in Texas, in which basically it says that due to a cause of insupportability, a petitioner can file for divorce against his or her spouse, and that the courts may grant the divorce based on the claim of insupportability. Now, I was served with this petition. The original petition was taken to the court on July the 8th, 2025. I was unaware of it until almost a month later that this has actually been filed. And obviously, I did not want this. I don't think that this is legitimate. There's a lot of stuff I'll go through here possibly sometime in the future. And basically, the grounds for divorce are the marriage has become insupportable because of discord or conflict of personalities between petitioner and respondent that destroys the legitimate ends of the marriage relationship and prevents any reasonable expectation of reconciliation. I deny this 100%. This is actually incorrect. This is basically just writing the statute down. These are the magic words that Texas has put into place in the Texas Family Code. And I've had attorneys tell me, oh, if you say the magic words, you will get a divorce against your spouse. And I've watched Judge Mary Brown on one hearing when she kept on asking this one guy, has your marriage become irreconcilable? Does it prevent any reasonable expectation? She wanted him to say the magic words. And he was like, no, not really. And then eventually he kind of said, well, I guess it has. And that's the basis upon which she granted the divorce to the petitioning wife. He did not want the divorce. It was forced divorce, divorce on demand. There were no reasons given for the divorce. It was just that the allegation that was stated that the marriage has become insupportable because of discord or conflict of personalities between petitioner and respondent that destroys the legitimate ends of the marriage relationship and prevents any reasonable expectation of reconciliation. Once again, I completely denied this, and in addition to my denial, my response that I offered, I also decided to file a constitutional challenge to the statute. The statute has many, many constitutional infirmities. It is unconstitutional from the get-go. In fact, in 2001, there was a Justice Kem Thompson Frost, who said there is no way to reconcile this statute with Texas's acknowledgement of marriage as being an institution from God, and that this violated the respondent's right to try to keep his marriage together. And at the time, she was in the minority. There was a 2-to-1 vote, and she was in the minority. But I believe what she did is that she laid the groundwork out for a future generation to pick up this argument and to run with it, and to show that this statute, 6.001 of the Texas Family Code, is completely unconstitutional. There is no way that the legislature could reconcile this statute with Texas jurisprudence. So in my response to dismiss the original petition for divorce, I wrote this: now comes Jeffrey Stephen Morgan, respondent in the above captioned matter, and files this motion to dismiss petitioner's original petition for divorce pursuant to Texas Rule of Civil Procedure 91A and for the lack of subject matter jurisdiction, and would respectfully show the court as follows. Number 1, this motion challenges the constitutionality of the Texas Family Code 6.001 as facially invalid under the United States and Texas Constitution. Number 2, as an unconstitutional statute is void ab initio and cannot confer jurisdiction upon this court. That was Norton versus Shelby County, 118 U.S. 425, 442, and 1886. Number 3, the Texas Family Code 6.001 violates multiple constitutional provisions, including, but not limited to, due process. And this is under the U.S. Constitution, the 14th Amendment, and also under the Texas Constitution, Article 1, Section 19. Equal protection. The U.S. Constitutional, again, the 14th Amendment, freedom of speech, the U.S. Constitution, the First Amendment to the U.S. Constitution. These, by the way, the First Amendment is in our Bill of Rights. These are rights that we have against our government. It's trying to oppress us. We needed to have certain rights that were granted to the people. In the Bill of Rights, we have the freedom of speech And this statute violates freedom of speech through viewpoint discrimination, which I will get into in a future video. It also violates the separation of powers doctrine as contained in the Texas Constitution, Article 2, Section 1. Religious freedom. The United States Constitution, the First Amendment, grants us also the freedom of religion. The Texas Constitution, Article 1, Section 6, grants us freedom to worship Almighty God, and no matter whatever is the state allowed to interfere with our worship according to our conscience. And also there is the Texas Religious Freedom Restoration Act, which has been codified in the Texas Government Code 110.003. Also the Contract Clause. In the United States Constitution, Article 1, Section 10, there is the contract clause regarding that the government should not violate the obligation, shall not undermine the obligation of contracts. This is also contained in the Texas Constitution, Article 1, Section 16. The respondent files contemporaneously herewith this memorandum in support of motion to dismiss, incorporated herein by reference, detailing the constitutional infirmities of 6.001. The respondent is likewise filing the required notice of constitutional challenge pursuant to Texas Government Code 402.010 to this court and to the Texas Attorney General Ken Paxton. So we have already done this as well. I'll go into that just in a few moments here. If the motion is denied, the respondent demands a jury trial as to this cause of action. Wherefore, premises considered, the respondent respectfully prays that this court will dismiss the original petition for divorce for lack of subject matter jurisdiction and grant such other relief as set forth in the accompanying memorandum. And this was dated the 8th day of August 2025. Jeffrey Stephen Morgan, respondent pro se, gives my contact information and stuff like that.